Welcome to Looking at Legal Stuff. Today we have a quick clip with a woman who is trying to have a violation hearing for her PPO against her ex, but the judge isn't even sure if it's a valid order. He takes testimony to try and determine what's going on, but she can't seem to give a straight answer, nor is she very happy about the situation. Should there even be a violation hearing? Let's see what the judge thinks.
We are here in the case of Angela Taylor versus Paul Colby II, case number 23-10503 PP. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court this afternoon. This is the time and place scheduled for a hearing on whether or not Mr. Colby violated a personal protective order entered by this court. It appears back on in or on or about November of last year. Now, I have met with the counsel before the protective order, before the hearing today, to kind of get a sense of what's happening, as I often do. And a couple of things of concern have come up. The first is an order of Judge Kometz, referee Kometz, that was signed and countersigned by me. Looks like, or at least filed in my court file here, November 13th, 2023. It is captioned an order dismissing the motion to terminate the personal protective order and leaving the personal protection order in place, as if referee Kometz did not terminate the order at the time. However, I did read the body of the order, which states that it is ordered that the respondent's motion to terminate the ex parte personal protective order is denied, and the personal protective order shall stay in place for reasons stated on the record, period. And then next line underlined, this personal protection order may not be extended pursuant to MCR 3.707 as of January 8th, 2023. This case is dismissed nunc pro tunc, which is a fancy Latin for term meaning I'm dismissing it because I'm the judge. I don't know what Judge Kometz meant by that. It does say two conflicting things. In one hand, it could be read to say that this is supposed to stay in place and that the hearing could be conducted on these alleged violations. And in the second case, it could be read to say that he did away with it and doesn't want, he thought that the case in its entirety, including the protective order itself, ought to be dismissed as of January 2023. Unfortunately, it doesn't appear that either counsel were present at the hearing in front of Judge Kometz, and I'm going to have to reach out to Judge Kometz with a copy of the order and get his opinion on what he meant by that. So in any case, we're not going to be able to proceed today with the hearing on the violation until I figure out what Judge Kometz intended to do, and I approved by signing his order, as I almost inevitably do, because Judge Kometz demonstrates very sound judgment and practical ways of resolving these orders. Secondarily, counsel for the respondent, Mr. Colby, is Ms. Lopez. She raised the issue that there may be other proceedings that are ongoing in Mecosta County, where at least it appears that Ms. Taylor lives, and that may govern at least, along the lines of a custody order governing the child that were not initially disclosed when this order was filed for. If that's the case, I may make a finding today that this was void from the inception and just dismiss it in case that's not what Judge Kometz intended to do.
Excuse me, Your Honor. There is not a custody battle going on in Montcalm County.
All right. Well, I'm going to take some testimony from you, but first, as an initial matter, let me ask counsel to place your appearances on the record.
Lauren McNabb on behalf of Angela Taylor.
Thank you.
And Tamara Lopez on behalf of Mr. Colby.
Very good. And Ms. Taylor, since this was yours right off the outset, let me get your testimony on what's going on up in Montcalm. If you please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right. What are you aware of that's filed currently in the Montcalm courts?
There isn't anything in Montcalm courts.
Now, my impression was that at some point, both you and perhaps Mr. Colby filed for protective orders up there. What's going on with those? That's you, Miss Taylor.
I filed one in the end of October and it got denied.
Okay, and then you filed this one also the end of October? And I approved it?
Yes, because he's been damaging my property.
Well, I just look at what I read here. I don't find to make any factual findings, and that's why the other
And then
person
he's
has
been harassed. He's been coming to my work
All right, well,
harassing me.
let's not get ahead of ourselves here. Let me get a little more clear picture about what's happening. So at the time you filed this, what was the status of your filing for a protective order in Montcalm County? Did you have them both at the same time that you asked for them? Did you ask for Montcalm and get denied and then file here? How did that work?
Yes, I filed in Montcalm and I got denied. So then I waited and then I went to Kent County
How long did you wait?
like 3 weeks later.
Okay. All right. And you figured, well, I got denied in Montcalm, I might as well try in Kent.
I was already in Kent County when I filed because I haven't been able to stay at my house because he damaged my property.
And your house is this, well, I mean, I know you've got some confidential information here I don't want, but is your house in Montcalm or in Kent?
Montcalm.
Okay, but you were staying in Kent and thus you thought, well, I'll file the motion in the protective
Yes.
order in Kent. And at the time, at least you listed a address for Mr. Colby on Egner Street, Cedar Springs, Michigan, 49319, making it appear that he would have a Kent. Is that a right address for him?
Yes.
Okay. All right. Tell me about what the status of any custody orders involving the child that I wasn't even aware of when this was filed might be.
There wasn't any custody battle going on.
Is there a custody order in any court?
No.
So there's no order providing child support custody or anything like that for your son?
I pay child support.
Then you're probably doing that pursuant to an order. But you don't think there's any court order that governs it in parenting time, things of that nature?
No, I don't get I don't even get to see Tristan.
So what's the kid got to do with this whole thing?
Nothing.
Well, now and then your daughter is also engaged. Is she an adult?
Yeah, she's 20.
Okay, so there's obviously nothing involving her. If there is an order involving Tristan, where does that come out of?
Montcalm.
Okay. You're just not aware of what the case is, or for that matter, if there is, I mean, was it pursuant to a divorce? Any idea?
We've never been married. Me and
Got
Paul
it.
Colby have never been married. And that's what he's been telling everybody, even the cops.
That you're married.
Yeah. And then
Hmm.
we've been together for 18 years and he's lived with me. No, he's never lived with me. All he keeps doing is lying to these courts. Because Judge Krieger even caught him out in a lie too.
Well, I don't know what Judge Krieger said. I'm just trying to get to the bottom of what mine is, and I'm certainly not going to conflict with anything that Judge Krieger found up there in Montcalm. After all, she is the county circuit judge for that county. And one thing us judges hate is to get orders that we don't know about the other court's order and we conflict with each other. So I'm trying to avoid that at all costs here, including with Judge Kometz. What's your perception of what Judge
Because I
Kometz
got
wanted to
lots
do?
of proof I could show you.
What did Judge
I
Kometz
can bring
intend?
it down. like-
Well, today's not the day for it. I still got to figure out what happened at the last hearing. What happened in front of Judge Kometz from your perspective?
He said he violated them.
Well, he wouldn't have found a
Damaging my
violation.
home.
He was ruling on an objection to it. So you think he kept the protective order in place? He didn't dismiss it, but he just said you couldn't extend it any longer after it expires.
Yes.
Okay, which would still make it potential to have a violation hearing as of today. I just need to double check with Judge Kometz and see if that's what he intended to do. Okay. Ms. McNabb, do you have any questions for your Ms. Taylor?
No, Your Honor, not at this moment.
And Ms. Lopez?
Yes, Your Honor. Briefly, I'm holding up what's a order between you and Paul that was ordered of the court of Montcalm County in December of last year regarding your son, giving him sole custody. You don't recall that?
Full custody. We just went to court on this year.
Back yesterday.
You were just there yesterday, correct?
Yes. But we already went in front of a lady before we went in front of the judge.
But this case has been pending since 2008. There's just been several hearings on and off throughout the years,
Yes.
correct?
I don't even know what you're talking about from 2008. Because I had custody of Tristan.
The
He
case
just
numbers,
continues to lie.
All right,
I'm
please let her ask the questions and then give your answer. Go ahead, Ms. Lopez.
you must have filed for child support in 2008 or something, because the case number is 2008. Do you disagree with that?
Yeah, now I understand what you're saying. Yes, I filed child support in 2008.
Okay, and yesterday you had a hearing regarding this matter, correct?
Yeah,
Okay. And you did not disclose that on your petition for protection order when it asked you, are there any other pending actions regarding the parties?
there wasn't anything.
Wasn't there a PPO that Paul took out on you?
Because Cora had Tristan when all this stuff went down in
Ma'am?
June.
Did Paul take a PPO out on you?
No,
You didn't have a hearing on November 1 with Judge Krieger regarding the PPO that she denied.
my PPO was already in place. I had one on my daughter that I went in
No.
front of the judge.
On Wednesday, November 1, you appeared before the judge regarding a personal protection order. You don't recall that? And you told the
Against
judge,
Paul, but Paul
Yeah.
never had one on me.
it says Paul Colby petitioner versus Angie Taylor petitioner.
Oh, yeah.
Okay, so there were at least two pending cases.
But my paperwork was put in way before this.
Or what?
So I have no further questions, Your Honor.
Yeah, no, okay, all right. Any follow-ups, Ms. McNabb?
No, Your Honor.
Okay, well, what it's succeeded in doing is thoroughly confusing me as to where this case should or could currently stand. I will say this, if there were pending actions, be they custody actions, support actions, or pending personal protection orders, and they weren't disclosed when this was filed as of October 23rd, 2003, and I find that I will dismiss this void ab initio, which is another fancy Latin term meaning as the minute you filed it, because it contained a lie. So I'm going to go back and research the relevant court files. I'd invite either party to submit portions of the relevant court file to the court. I will make those determinations and determine whether or not this order should be allowed to stand in the first place. At the same time, I will still contact Judge Kometz and see what his intention was, whether it was to leave it in place or not. Once I've sorted all that out, whether there is an order or not, and whether it remains in place and enforceable, then perhaps we'll set up another hearing on the alleged violations of the protective order. In the meantime, if Judge Kometz indeed, intended to leave this in place until its stated expiration date, which is April 24th of 2024. The smart thing on your part, Mr. Colby, would be to obey that protective order so as to stay out of any potential legal jeopardy between now and then. Given the fact that I still may hold a hearing on 3 prior violations. We don't want to add any more sticks to the proverbial fire, as it were. So in that case, why don't we treat it like it's in place until I issue an order clarifying the situation. I will do that after reviewing submissions of the parties. Any submissions of the parties are to be done within 1 week of today, which by my math would make, what is it 1 week from today, Lisa?
1 week from today would be February 2nd.
Any submissions by the parties to be submitted to the court no later than close of business February 2nd, 2024. I'll review transcripts, filings, whatever you've got to verify the dates in this matter, and I'll make my ruling after that. If I need another hearing, I will notice it up, and then I'll let you know if there are to be additional hearings to follow. In the meantime, I'll email Judge Kometz and ask him to clarify what he meant in his order. Anything else we need to place on the record at this time?
Yes, Your Honor.
Oh,
Where
let me
do
go,
I
Ms.
bring the
McNabb first.
paperwork to?
Your Honor, I just would like to place a general objection to dismissing the PPO on the record.
Very well. And Ms. Lopez?
No, I'm in agreement with the objection, obviously, and I will provide the paperwork to the court.
Very good.
I'm gonna do the dismissal.
And Ms. Taylor, you had a question.
Where do I bring my paperwork to?
You can submit it to my chambers. You can either email it if you have electronic copies to Lisa, and she'll gladly give you the email address, or you can mail it to me at 180, or you can deliver it to the courthouse, to the clerk's office, 180 Ottawa Northwest. Attention, Judge Rossi.
Okay,
And
can she just email that to the
anything that
address?
you submit, make sure you submit a copy of it to both Miss McNabb and Miss Lopez, so that we're all on the same proverbial sheet of music as I'm deciding this. So make sure you get copies out to the other parties, be it electronic or paper. Just make sure everyone else knows what is being submitted to the court, so we're not having another Latin term, ex parte conversations. That means a conversation with the judge without the other parties present. Not allowed to do that either. So, all right. So do submit the paperwork to me within the next week, however you're able to do it. And Lisa, if you would stay on and give Ms. Taylor your email, that'd be great.
Yep.
With that, we're concluded.